First of all, I'd simply like to say welcome. Welcome to the panelists, to those of you who are here in person. And I'd also like to welcome all of you who are online. What we've noticed recently in these events is often we have 3 or 4 times the number of people dialing in and participating than we have in person. It's also something we need to keep in mind when we have a panel, that the audience is also available someplace in a virtual space, and we should be looking where the cameras are and the light. Well, I should say we've had a few panels now thinking about the implications of Ukraine, and I regret to say that it's now day 19 after the Russian invasion of Ukraine. There's a serious humanitarian crisis that's building. Around 2.6 million is the estimate of Ukrainians who have indeed left the country. Over 6 million, that the estimates, according to the UN, are internally displaced. And of course, I'm just talking about people on the move. I'm not talking about what's happening in the cities that have been attacked, bombed. And the pictures that we see on TV, I think, are definitely evidence in terms of basically the level of destruction. That was the physical side of this. This panel is to discuss international legal dimensions of the invasion. They are plenty. They are constantly changing, indeed, as the facts on the ground change and as the responses of the international community evolve. Now, I'm coming simply to introduce the panelists. I'm delighted to have several panelists here today, and I'm going to go through the panelists simply in the order in which they will speak. Başak Çalı, I think most of you know, is a professor of international law at the Hertie School and co-director of the School Center for Fundamental Rights. She will serve as the chair of this panel. Broude is the Bessie and Michael Greenblatt Chair in Public and International Law at the Faculty of Law and Department of International Relations at Hebrew University of Jerusalem. Cathryn Costello, I hope you also know, is also a professor of fundamental rights at the Hertie School and co-director of the Center for Fundamental Rights. She also does a lot of work on international and European refugee and migration law, which clearly is directly relevant today. Yulia Ioffe is a judge of the European Court of Human Rights. From 2015 to 2016, she served as vice president of Section 5 of the court, and from 2017 to 2019 as president of Section 4 of the court as well. Yulia Ioffe is an assistant professor in international human rights and humanitarian law at UCL Institute for Risk and Disaster Reduction. And her research also covers refugee rights, children's rights, and the law of treaties. Last but not least, Alexandre Skander Galand is a postdoctoral researcher here at the Center for Fundamental Rights and a lecturer at the Hertie School. He has specialized in international criminal law, international human rights law, and international humanitarian law. I would also, in general, like simply to thank Judge Ioffe and Dr. Ioffe for accepting to come to this panel at such hard times when they have close family and friends in Kyiv and elsewhere in Ukraine. So I very much look forward to this panel. Başak, the floor is yours.
Good evening, everyone joining us online and also on site here at the Hertie School. Thank you, Mark, for that introduction of the panel and the panelists. It is my pleasure to chair this panel with such distinguished experts on international law and the invasion of Ukraine. The invasion of Ukraine by the Russian Federation exposes various functions that international law fulfills, as well as many weaknesses of international law as well. So we're here this evening to talk about these, the functions and the weaknesses of international law in making sense of the invasion in Ukraine. Perhaps we could distinguish about 4 different functions that international law has in context of this invasion. The first one is international law offers the key legal terms and concepts: the act of aggression, neutrality status, belligerent status, who is a combatant, who is a mercenary, or who is a prisoner of war. These are terms that are used by journalists, by politicians, by military, by lawyers, by humanitarian workers and NGOs currently, and what these terms mean really take us back to international law. The second function of international law is to identify what is violated, what are the violations of international law that are currently at stake. The third function, I think our speakers will focus on this very much today as well, is international law's ability to specify what is required, permitted, or prohibited when a state violates international law. So what are the responsibilities of others, rather than saying there's a violation of international law? And of course, the final and the fourth function is to talk about legal routes of accountability for states, for individuals, for corporations, for anyone who is engaged in activities that violate international law. So let me just talk about the violation aspect very briefly. Now, the most flagrant violation of international law at stake here is the aggressive unilateral use of force, which is prohibited under the United Nations Charter. This is an act of aggression, not anything else but act of aggression, for three reasons. First, states can only use force in self-defense when they're attacked by another state, or when they are genuinely invited by another state who is under an attack, or when that action is authorized by the UN Security Council. In the invasion of Ukraine, none of these are applicable. Ukraine has not attacked the Russian Federation, and there is no United Nations Security Council resolution. Instead, what we see is that Russia is using international law to invoke two different arguments. One is long-term risks to its security because of Ukraine's pro-NATO policy, and invitation by two regions of Ukraine, which Russia recognized as states on the 21st of February, and the need to collectively defend these entities against what Russia calls a genocide by Ukraine. Now, I submit that none of these actually can justify this use of force or this invasion, and on the contrary, that this is an act of aggression. One, long-term security concerns cannot trigger the right to individual self-defense under international law. A single state's unilateral recognition of another state's regions as states also cannot make these entities states, and there is no credible evidence that is submitted by Russia that peoples in these regions were subject to genocide that may justify possibly remedial secessionist claims. So this means that Russia's acts do not fall under any exception, but actually a very clear violation of the prohibition of aggression in international law. Now, alongside this, and I think this is the most important violation that we have to identify, there are lots of other violations that we may talk about in the context of hostilities, war crimes or crimes against humanity that emanate from using indiscriminate weapons, carrying out indiscriminate targeting, or not offering humanitarian support to populations that are under siege. And we hear more and more reports about these crimes, but obviously these crimes are separate from the crime of aggression that I have just outlined. So when a crime of aggression or the prohibition of aggression is violated or this act is committed, who is to do what? What are rights? What are obligations? And what is permitted and what is not permitted? Obviously, the Ukraine has the right to self-defense, and it is exercising its right to self-defense under these circumstances. Now, all other states are permitted to collectively use self-defense in order to actually combat this aggression. But what we're seeing in the international arena at the moment is that no state is willing to use their collective right to self-defense in support of Ukraine, despite many calls from Ukraine to that effect. They're not required to do this, but they're permitted to do this, and they're not using this. Now, instead, Western states, mostly Western states, are pursuing a no boots on the ground or no plane over the skies policy. And with this, they hope to convince Russia that they are not a direct party to this conflict as a matter of international law. Now, only the time will show if this, actually a very legal argument, is going to be found persuasive by the Russian authorities as the conflict continues. Now, what is prohibited? Obviously, all states are currently prohibited to aid or assist the Russian Federation. This is a very clear prohibition, and reports about the Belarusian assistance violates this. And also we will see again in the coming days, if other states cooperate to defy the sanctions imposed on Russia, whether they will be seen as acting in prohibitive forms in the face of an act of aggression. Now, there's an obligation on all states to cooperate, to put an end to an act of aggression, and that they have a duty not to recognize any of the legal consequences from an act of aggression. But as you know, it is the primary responsibility of the UN Security Council to coordinate all efforts when there's an act of aggression. And the UN Security Council is unable to function. It's a completely dysfunctional entity at the moment. And for this reason, we see a very highly decentralized form of cooperation among states. So some states are supporting Ukraine through provision of lethal weapons and sanctions. Some refuse to provide lethal weapons, but only humanitarian aid and some sanctions. Some do not impose either sanctions or support with lethal weapons or by humanitarian support. So we see a very highly decentralized form of responses, and it is unclear whether these responses meet the obligation to do everything in your power to actually put an end to an act of aggression. Now, with this framework of violation, and I think the biggest violation that we must really focus on is the prohibition of aggression, let me turn to Professor Broude, to Tomer, to talk about sanctions. Do you think that the states are doing all they must and they can to put an end to this aggression with the sanctions that have been imposed so far? Thank you, Tomer.
Thank you, Başak, for this strong opening statement that I fully subscribe to, certainly in the questions and also in some of the intimated responses. I think if you asked a yes or no question, I think my response would be no, not doing enough. But I'll try to add some grain to that, even though I only have a few minutes. So as the sometimes international economic law person in this roundtable, so I've been tasked with discussing the issues of economic sanctions, and there are many issues, and the scope is incredible, right? I mean, we're talking about trade, investment, tax, finance, private, public, and these are issues that can be looked at from a general public international law perspective, but they cover so many different fragments and levels of domestic, regional, international law blended in. So by way of overview, of course, like I said, the span of economic sanctions in place now and that are being discussed. And I think that's important to, there's what's already in place. Its effectiveness is questionable, but there are, and that's another issue that I'd like to at least pick point. But there are other things that can be done. So cutting off from the main financial transfer service, SWIFT, freezing of bank accounts, foreign reserves, withdrawal of most favored nation treatment in international trade, which is a point that I'd like to address in a little bit more detail, ostensibly cutting off Russia from the global economy. And these are all unprecedented in the 21st century. That's an easy play, perhaps, if we're only looking at the 21st century, but in several ways. First of all, this is an actual clear-cut, it's a clear-cut violation of and severe violation of international law. It's not an impending or imminent. This isn't Iran. It's not Venezuela. It's not North Korea, and there are violations that I think that are quite clear, both ad bellum and in bello, and human rights violations on a massive scale. Russia is also an economically globalized actor, right? It's in the sort of Q1. It's in various indicators, it's still in the top 50. And heavily invested, definitely in energy, but it's this sort of demonstrates that economic sanctions are also a double-edged sword, because it is very much susceptible to the effects of sanctions, but sanctions also work the other way around. In other words, we have to take into account the effects on the global economy. Russia is also a member of the UN Security Council, of the G20, of the WTO. It's not only economically, but also legally and institutionally enmeshed in the global system. The speed and acceleration of the sanctions has also been incredible or unprecedented, raising the question, why were they not imposed before? And I'm not only talking about the Crimea playbook, but with respect to the concerns about Ukraine. And then we also have the added element of non-state actor sanctions, which I think are also unprecedented in scale. You can go to #LeaveRussia and see the ongoing elements of different private actors that are taking or withdrawing from the Russian economy. From a legal perspective, there is a legal perspective, not to be flippant, but the legal basis for sanctions should not be questioned in general. These are either retortions, obligations not to recognize legal or illegal effects of aggression, and they do not or should not make any of the actors taking action belligerent party in themselves. At least there's not a precedent for that. So overall, there are no universal obligations that are being violated by such sanctions. That doesn't mean that there aren't particular ones based on multilateral agreements and if they're bilateral investment agreements and so on. I think an overarching question is, what are the goals of the sanctions? Are they just a public relations exercise? Do they have symbolic value that goes beyond that PR element? Are they supposed to induce compliance? Are they supposed to promote regime change? These are all questions that have political economy dimensions. Are they supposed to pressure the strongmen in Russia? Are they supposed to pressure the oligarchs and or to choke the military complex, hurt the people? You know, all of these also have legal dimensions in terms of the object and purpose of the actions being taken. If I have another minute, then I'd just like to address also the WTO dimension, the World Trade Organization. So several states have announced withdrawal of most favored nation treatment in the WTO. This in itself, I think it does have some symbolic effect. It shouldn't have a lot of economic effect. It really is supposed to just be a release, not just in tariffs, but also in non-tariff measures, intellectual property, across the board services. But it really depends on what states will do with that release from most favored nation treatment. Myself, then I would advocate tougher measures in the WTO to the point of a waiver. Again, this is more technical language in the WTO that I can expand on later, but a waiver of WTO obligations vis-a-vis Russia based on the United Nations General Assembly condemnation that would permit states to take any action that any economic action that they see fit. I'll stop there.
Thank you. I'm hearing that you're saying that the sanctions seem lawful and more of this could actually be envisaged than less of it so far, but I'm sure we'll pick it up on the Q&A session. Cathryn, let me turn to you on obligations triggered by this invasion on behalf of others in particular. Could you take us to those obligations in relation to mass displacement and mass refugee flows, please? Thank you.
Sure. Thank you, Başak, for that very clear opening that I also endorse entirely. Well, it's been a long 19 days, even for those of us simply observing the events in Ukraine. And the figures are really astounding. And I say that as somebody who studies refugee issues, and where I generally feel that the word unprecedented is an abuse of the term. But in this case, we are talking, as President Halleberg said in his introduction, about, I think latest figures were over 2.8 million people having fled Ukraine in that very long, but nonetheless short 19 days. So that's, by some estimates, over 150,000 people fleeing the country every day. Most, of course, directly enter the EU. Thus far, we have over 1.7 million people who have fled into Poland, over 200,000 to Hungary, Slovakia, over 100,000 people moving into the Russian Federation, over 100,000 to Moldova, and so on. And many people moving onwards, as those of us who are in Berlin know very well that there are thousands of Ukrainian protection seekers arriving in Berlin and across Europe every day. So in this short talk, I wanted to discuss displacement within Ukraine and the right to leave, the treatment when crossing the EU's borders, and the status that has been granted by the EU to those fleeing Ukraine, which is a legal status of temporary protection, and what that means. And if I have some time, just reflect a little on the implications or possible implications for the global refugee regime generally. So Ukraine has had a large internally displaced population since 2014, when Russia invaded eastern Ukraine and annexed the Crimea. By some estimates, 1.5 million. It's always very difficult to count internally displaced people, because when somebody moves within their own country, that doesn't necessarily trigger a legal process or even necessarily in some cases registration. And international law typically views IDPs, internally displaced persons, as the concern of the state in which they find themselves. But there is an international regime on preventing arbitrary displacement, protecting people while displaced, and bringing internal displacement to an end. It's enshrined in guiding principles. Before the invasion, if an internally displaced person from Ukraine, as many did, moved onwards, they typically migrated. So there were many, and there are many, Ukrainians living and working across the EU as migrants, not enjoying any particular protection status. And I do think we need to start to think about their protection needs as the idea of returning becomes unfeasible. Several thousand every year applied for asylum in the EU, and generally speaking would be rejected. They would be told that there was an internal protection alternative within Ukraine. So this understanding of territoriality is built into refugee law. This idea that if you could flee within your own country, you should stay there. And so I just wanted to highlight that background, because against that background, what's the response in the form of temporary protection to those fleeing Ukraine today is all the more remarkable, and appropriately so, I would say. So concerning the right to leave today in Ukraine, obviously a massive practical problem is that it's simply too dangerous for many to flee, and that many cities are under siege. And thus far also there are extremely concerning accounts about the failure to even attempt to agree ceasefires or so-called humanitarian corridors, which would allow civilians to leave, and indeed humanitarian assistance to reach civilian populations. So this suggests that in the conflict, it appears that there are very serious violations of international humanitarian law taking place. There's very little information at the moment, but there's some very bad precedents in Russian conduct in 2014 around humanitarian corridors, and also from practices in Syria where humanitarian corridors actually became routes of mass coerced displacement of the population. So this is a matter, obviously, of grave concern, but nonetheless, people are successfully still leaving Ukraine. Now, when it comes to crossing Europe's borders, I suppose the most remarkable thing is just this question of geographical proximity, because for the most part, and the overwhelmingly, the country to which most people are fleeing is Poland, people are fleeing into an EU member state. And in that instance, they are crossing an EU external frontier, and Ukrainians do not require visas to enter the EU since 2017. Now, this also makes the situation legally remarkable, because the typical scenario, if one can think about that, of asylum seeking in Europe is that an individual is coming from a country which is on a visa list for the EU, and indeed, generally speaking, for most countries in the global north. And it's the requirement of a visa, which you can't get if you look as if you're going to claim asylum, plus carrier sanctions means that most asylum seekers in Europe have to make irregular journeys that are dangerous ones. They can't normally board regular flights and ferries. And this is the story of 2015, Europe's last so-called refugee crisis, that the protection seekers who would be recognized as refugees as soon as they arrived and posed asylum claims had to take dangerous journeys to do so. So the lack of visa requirement is highly significant, as is the fact that on the 4th of March 2022, the European Commission issued guidance to Europe's border guards, explaining the degree of flexibility that there exists under the Schengen Borders Code in quite a complex document. But what it has meant in practice is that those fleeing Ukraine, although there have been backlogs and queues and a certain level of checks at the borders, I mean, rightly so in the view of many people, but that nonetheless people are simply able to cross Europe's border. Now, when I say people, we're talking about principally Ukrainians who have electronic passports in particular, but not only. So there's a facility for other forms of flexibility to be granted. Now, this flexibility turns on conceptions of vulnerability that are written into the Schengen Borders Code, which has meant that it's easier for women and children, particularly Ukrainian-looking women and children, even if they don't have electronic passports, to leave. And that has produced discriminatory borders. And in a way, borders always discriminate. You know, they turn on the production of certain documents or fulfilling certain criteria in the view of a border guard. Our colleague, Dr. Grażyna Baranowska, has written very eloquently in many fora about Poland's differentiated border, because only a few weeks ago, the most pressing concern about refugees at Poland's borders were protection seekers, often from Syria, in some cases also from Afghanistan, who were at the Belarusian-Polish border and being pushed back. And that situation has not fundamentally changed. We've also had concerning reports, which have been verified, of persons of color having particular difficulties in leaving Ukraine. On the other hand, it's not unusual for, in a situation of mass displacement like this, for the question of what to do with people who are not going to become refugees, in other words, foreigners who've been living in this instance, Ukraine, to have questions about, well, where should they go? And the international system works on almost an assumption that foreigners who are caught up in a war should repatriate. So that would mean all the foreign students who were in Ukraine, for example. And the International Organization for Migration has a program for what are called migrants in countries of crisis, which has not been triggered in this instance. And in fact, against my background assumptions, I was actually quite surprised that there was almost an assumption that people fleeing Ukraine who were not Ukrainian nationals but had lived there should be offered some form of protection. Now, I'm not saying I don't agree, I actually agree with that if this should is, you know, morally and ethically, but in international law, this very statist system simply says, well, you should go back to your home country. Now, as it happens, the temporary protection measure that was agreed only covers explicitly non-Ukrainians who had an international protection status in Ukraine, so it's quite narrow, but EU member states are allowed to offer protection to others. And obviously, you know, that recognizes the fact that sovereign states can offer residence permits on a humanitarian or other basis to anybody they want. So this point that I'm making here about border crossing is that, again, this official relaxation, or let's say exploitation of the ability for Europe's borders to remain relatively open in order to allow very large numbers of protection seekers to enter the territory, I think is remarkable in this case. And I'm not at all diminishing the reported instances of difficulties leaving or differentiated borders, and in some cases, racialized violence. But on the whole, the numbers of people who are able to enter EU territory is remarkable. And then thirdly, and this is really the final substantive point I wanted to make, in terms of EU reaction, the triggering of this legal instrument called the Temporary Protection Directive also surprised everyone. So This is a directive that was adopted in 2001, very much with the Kosovo refugee experience in mind. So very much a smaller scale response, but also a response, you may recall, which led to a humanitarian intervention of questionable legality. But nonetheless, this idea very much to the fore that refugee situations could be managed temporarily because we, the EU or the West, had the power to fix things and then return people swiftly when conflict was over. So this instrument had this idea in mind that when people flee conflict, we don't need to decide if they're really refugees or not. We can offer them this temporary status. Temporary in this instance is relatively short, so it's a 3-year status. It was never again implemented by the EU in spite of academic calls to do so, but no serious political consideration even given to implementing it in 2015. It was seen as defunct. And the European Commission itself said this is a defunct and out-of-date instrument in 2020 and proposed that it be withdrawn. And on the 4th of March this year, this remarkable decision was taken in a few short paragraphs to offer this status to people fleeing Ukraine, and as I said, in some instances to foreigners fleeing Ukraine. I can discuss it in a little more detail, but maybe just to make 3 sort of brief points about it. Firstly, it's short. This is a status for 3 years. Secondly, Ukrainians and the others covered by it can decide where to avail of it. So the antithesis of the way the EU asylum system has run to date. This is free choice of country of asylum during at least for those 90 days when people enjoy visa-free travel. So responsibility sharing may have to be worked out later, but for now, Ukrainians can still avail of visa-free travel across the entire EU. And thirdly, it comes with a fairly decent rights package, including welfare rights, education rights, and the right to work from the outset. So there will be huge questions about what next, what happens after 3 years. But I think the political consensus, which after all included also Hungary and Poland, countries that are on the record with very hostile anti-refugee sentiment, is really remarkable. And seems like an appropriate response to meet international protection obligations in this case. Thanks.
Thank you. Thank you very much, Cathryn. So from the European Union, let's move to the Council of Europe and to the European Convention on Human Rights. And thank you very much, Judge Gana Judivska, for joining us from Strasbourg today. Russia has been a member of the Council of Europe since 1996. And what we understand now is this is the end, or very much almost the end. Could you tell us what legal issues arise in the context of Russia's membership? And it seems like it's current suspension and probably the termination of its membership to the Council of Europe. Thank you.
Thank you very much, Başak. Thank you, first of all, for the invitation. And at this most horrible time in, I think, the whole post-World War II history, many of us, we just exchanged a little bit with you before, if not all of us, question our whole careers as international lawyers, as human rights lawyers, and as protagonists of the rule of law. Yes, it's true that Russia is a member of the Council of Europe as of 1996. As several years ago, long before, of course, the conflict started, Eric Posner observed that the Council of Europe presided over a return of authoritarianship to Russia. Now, how true is it? I think we will reflect a lot in the nearest future. Yes, it is very much true that now the proceedings for, so to say, expulsion of Russia from the Council of Europe started. No one knows exactly today how they will develop, so for how long Russia will remain member of the Council of Europe is one thing, and also state party to the convention, to the European Convention on Human Rights. But today, Russia is still high contracting party, which means the convention should apply. And the court, even when Russia leaves, according to all the relevant norms, the court will be obliged to examine all cases pending today before the court, plus all cases submitted concerning alleged violations committed by the Russian Federation during the time it was still member of the Council of Europe and member state of the convention, which means if something goes on today and then someone is obliged to exhaust available domestic remedies and he or she is not satisfied with the result, he or she might come back even if several years passed since Russia left the Council of Europe. But again, no concrete mechanism exists today. Well, we have only one example, Greece in 1967, but it's a very different example, and I will not now cover it. But what we have today also is, of course, interstate cases pending before the court against the Russian Federation, including, of course, cases related to the conflict between Ukraine and Russia. We had the first case and already the first admissibility decision in the case Ukraine versus Russia, Re Crimea. A couple of months ago in January, we had hearing and first deliberations in the case Ukraine and the Netherlands versus Russia, Donbass. It concerns events in Donbass in 2014 and afterwards, and including downing of the plane MH17. And finally, Ukraine submitted on 1st March 2022 its Rule 39 request for its new application regarding this aggression. So a couple of words about this court's initial reaction to the conflict which is pending. So in reply to the to Ukrainians' request on application of the interim measures, the court applied interim measures and considered that the military action of the Russian Federation that started on 24th of February in various parts of Ukraine gave rise to real and continuing risk of serious violations of the Convention, precisely under Articles 2, 3, and 8 of the Convention. Now, this is not something new. Those who follow the court's work now would know that Rule 39 interim measures were applied in the context of military operations in Georgia versus Russia, in Ukraine versus Russia, both Crimea and Donbass case, and the last, by the way, the last Rule 39 applied in the context of Donbass case is still in force. And then in the case of Armenia versus Azerbaijan and Armenia versus Turkey, the most recent cases in 2020. However, if you compare the language, the scope of the measure and the language used, you will see that the current interim measure applied 2 weeks ago on 1st March is significantly different. First of all, and I think it's very meaningful and you should pay attention to this, all previous measures applied by the court were addressed to all parties concerned, all parties involved into the conflict. Russia, firstly, Georgia, Ukraine, Azerbaijan, Armenia, and even Turkey, in the last case, Armenia versus Turkey, which is of course understandable because military activities of all parties involved potentially give rise to a risk of violations of the rights of civilian populations. But in the present case, the interim measure was indicated to the aggressor only, to the Russian Federation only. Now, second difference, if in previous cases the interim measure applied was very laconic, very brief, and it repeats itself in all the measures applied. The court called upon contracting parties to refrain from taking any measures, in particular in military action, which might entail breaches of the convention right. In the current measure, the court was far more explicit, and let me quote, the court decided to indicate to the government of Russia to refrain from military attacks against civilians and civilian objects including residential premises, emergency vehicles, and other specially protected civilian objects, such as schools and hospitals, and to ensure immediately and safely the safety of the medical establishment, personnel, and emergency vehicles within the territory under attack or siege by Russian troops. So, and then, so you see how wide it is comparing to the previous measures. And then in response to a number of similar requests for interim measures, but not from the state of Ukraine as such, but from many individuals who applied to the court, being inside the events, being blocked in Kiev, in Mariupol, in Odessa under bombing. And they requested the court to intervene. So the court said, and I quote again, so the court somehow widened the interim measures, and the court said, taking refuge, concerning individuals, so the court identified, so to say, individuals, all, not only those who applied, but all potential victims, those taking refuge in shelters, houses, and other buildings, fearing for their lives due to ongoing shelling and shooting, without or with limited access to food, healthcare, water, sanitation, electricity, and other interconnected services essential for survival, in need of humanitarian assistance and safe evacuation. The court said explicitly that they are already covered by the measure applied on 1st March, but moreover, the court decided to indicate to the government of the Russian Federation that they should ensure unimpeded access of the civilian population to safe evacuation routes, healthcare, food, and other essential supplies, rapid and unconstrained passage of humanitarian aid, and movement of humanitarian workers. So for the first time, the court explicitly called for humanitarian corridors, in addition to actually asking the aggressor to refrain from military actions capable to put in danger life of civilians. Now, you know that these days the ACG also was examining the request by Ukraine in the interstate case to apply provisional measures. I will not address it, I think Yulia will address it later. But to conclude on the provisional measures, of course, while the original purpose of any interim measure is to preserve a right from irreparable damage, in the interstate cases, again, in cases related to military operations, not expecting much enforcement, yeah, we are not so naive, but the court contributed to confirmation of the basic principles upon which the whole convention is built, as it's stated in its preamble. So those fundamental freedoms, which are the foundation of justice and peace in the world, are best maintained by common understanding and observance of human rights. Of course, military aggression is by definition negation of human rights, but at least a clear guidance, including judicial guidance, like in this case, should regulate the limits of military operations to minimize human rights violations of the civilian population. However, fundamentally, where a state fails to comply, the indicating body is limited in the steps it can take to enforce the order. Yeah, so international courts, including the European Court of Human Rights, do not have direct enforcement mechanism. Unlike domestic proceedings against individuals, where the court has tools in its disposal, on international level, unfortunately, in proceedings against the states, the primarily means of enforcement is a political pressure from other states and international organizations, which we all observe nowadays, and this is what just was discussed. So the court's judicial voice is also a kind of food other states and international organizations can use in explaining their action. And finally, my final word about the interim measure applied. Again, comparing to all previous measures applied in the context of interstate cases, something we should reflect, and unfortunately I cannot say more, being sitting judge in the cases and having limited freedom of speech, but just something to reflect, and it will be also for reflection for us as well as judges. This is the first interim measure applied in the context of ongoing military operations after the court pronounced at the beginning of 2021 the judgment in the case Georgia versus Russia 2, in which the court stated that the convention does not apply to the ongoing military conflict, to the ongoing military operations. Because briefly, of course, there is an explanation on 2 pages, but briefly, when 2 states struggle for jurisdiction, no one has jurisdiction. I voted against this decision. I put my separate opinion. I will not now reflect on this, but just again, here the court applied interim measure in the context of ongoing military operations against the background of Georgia versus Russia 2. And this is something we all lawyers, judges will reflect upon in our further examination of the case. Thank you very much. I will stop here and I will continue in the second round. Thank you, Başak.
Thank you. Thank you very much, Judge Ioffe. I mean, so far, I think we've heard the word unprecedented or never seen or never happened quite frequently in all of the legal contexts that we're actually discussing so far. So I'd like to turn to Dr. Ioffe, if I may. There she is. Hi. Hi, Yulia. It's lovely to see you. I wanted to follow up on the recent developments before the International Court of Justice. So just as the invasion started, we have also heard news that Ukraine has launched a case against the Russian Federation. And to some, this was quite surprising that, you know, people had the time to prepare a case before the ICJ in the midst of a conflict. But I think you will take us through this and why this has been done. What is the significance of...
Thank you so much for inviting me. It is a pleasure to be part of such an excellent panel. As Başak said, I will speak about Ukraine's most recent case before the International Court of Justice, and we'll focus mostly on jurisdiction and talk briefly about compliance, and we'll of course question the effectiveness of appeal to international courts more generally. So on the third day of armed conflict, on 26th of February, Ukraine filed an application instituting proceedings against the Russian Federation before the International Court of Justice, or ICJ, concerning a dispute relating to the interpretation, application, and fulfillment of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, or the Genocide Convention. This is not the first time Ukraine is attempting to address Russia's behavior at an international forum. In fact, since 2014, when Crimea was annexed and when Russia started the support of separatist movements in Donetsk and Lugansk regions, Ukraine has devised and pursued a complex litigation strategy before international courts. Specifically, Ukraine has already a pending case on the merits before the ICJ under the Terrorism Financing Convention and the Convention on the Elimination of Racial Discrimination with regard to annexation of Crimea and armed conflict in Donbass since 2014. As already mentioned by Judge Ioffe, a number of interstate and individual cases are pending before the European Court of Human Rights. There are proceedings before tribunals constituted under Annex 7 of the UN Convention on the Law of the Sea, under the WTO dispute settlement system, before the International Criminal Court, and before investor-state arbitration tribunals. So since 2014, Ukraine has been using all available remedies in international law to protect its rights and the rule-based international order more generally, spending a lot of time, efforts, and frankly, a lot of money on it. Indeed, it is ironic that the main slogan of the pro-war propaganda in Russia now is the question, where have you been for the last 8 years when people in Donbass were dying? And I think after what I summarized right now, it is visible that these 8 years, Ukrainian government has been busy trying to settle the dispute in a peaceful way and protect the rights of its citizens. The multiplicity of the cases that I just mentioned is explained by the fact that there is no court of general jurisdiction in international law. The closest to such court is the ICJ, but only in cases where there is a declaration pursuant to Article 36(2) of the ICJ statute, accepting the court's compulsory jurisdiction. Russia does not have such declaration in place. Therefore, Ukraine has been using compromissory clauses in a number of treaties to grant jurisdiction of the court. Previously, the Terrorism Financing Convention and the Convention on the Elimination of Racial Discrimination, and in the new case, the Genocide Convention. However, there is no treaty conferring the court with jurisdiction, for example, on the breach of the prohibition on the use of force or violations of international humanitarian law. As a result, the core of Russia's response to Ukraine's cases brought before the ICJ is accusations of so-called inappropriate shoehorning. That is the attempt of Ukraine to bring broader disputes under international law using the compromissory clauses of quite narrow and specific treaties. In fact, Russia's strategies has not included any attempts to deny alleged violations of international law, just that the court does not have jurisdiction. Going back to the new case based on the Genocide Convention, as everyone probably knows, last Monday, Ukraine presented its oral arguments to the ICJ in support of its request for provisional measures against the Russian Federation. And provisional measures are measures that are designed to protect the rights of the parties pending the final decision in a dispute. Ukraine, in particular, requested to protect its rights not to be subjected to a false claim of genocide and not to be subjected to Russia's military operations on its territory based on the use of the Genocide Convention under false pretenses. So the core of Ukraine's argument is that Russia based its use of force against Ukraine, apart from collective and individual self-defense, on so-called humanitarian intervention. That is the intervention to protect the Russian-speaking population in Donetsk and Lugansk regions against the genocide committed against them. Essentially, according to Ukraine, Russia's invasion is conducted pursuant to Article 1 of the Genocide Convention, an obligation to prevent and punish genocide, and on the basis of a false claim of genocide. It is worth mentioning that Russia has not appeared before the ICJ, but they did submit a written reply with regard to the requested provisional measures. The key point, as in the previous case, in the previous ICJ case, is that Russia is denying that the court has jurisdiction over any use of force issues since they fall outside the scope of the Genocide Convention. Specifically, Russia now denies that allegations of genocide against Russians and Russian speakers in Donbass have any kind of link to its use of force. As evidence, Russia points to the quote from Putin's speech as of 24th of February that talks about self-defense under Article 51 of the UN Charter. However, if we look at the next paragraph of the same speech, it says, the purpose of the operation is to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kiev regime. It is also worth noting that Russia's stance of not appearing at the oral pleadings, but making written submission is a weird mix of engagement and non-engagement. Non-appearance is unfortunately not unique to Russia and is part of worrying trend in international law. Most notorious example is the non-appearance of the United States in the Nicaragua versus United States case. Potentially, one of the reasons of such strategy by Russia is to try to delegitimize the proceedings before the court. This will likely inflict some damage to the ICJ authority. And it raises again the question, is international law a tool only for less powerful states? Is international law and its mechanisms only to be pursued by the states that do not possess nuclear weapons? The court is currently deliberating on Ukraine's request for provisional measures, and at this stage, it is unlikely that the court will make any pronouncements on whether Article 1 of the Genocide Convention in fact provides a legal basis for the use of force, but it is likely that the ICJ will grant provisional measures. And to conclude, a couple of words on compliance. The compliance with the ICJ orders on provisional measures has been problematic. In fact, Russia is still not compliant with the provisional measures from the previous case. And one of the reasons is that it is still not entirely clear how the monitoring of and giving effect to compliance should be achieved. Article 94 of the UN Charter provides that the Security Council with the power to make recommendations or to take measures to give effect to the ICJ judgments. However, as we all know, Russia's permanent seat on the Security Council, as always, makes things complicated. Thank you.
Thank you very much, Yulia, for this and also highlighting a lot of the structural weaknesses. And despite these, that Ukraine is pursuing all of these legal routes. So finally, before we will start to take some comments and questions, I want to turn to Dr. Galand and ask him about routes for individual criminal accountability in relation to the range of crimes that are continuously being committed or potentially may have been committed in the context of the Ukrainian invasion. Thank you.
Thank you, Başak. So before talking about the routes, I'd like first to stress what are the purposes that we're seeking when speaking about individual criminal responsibility for international crimes. So Yulia spoke about state responsibility also. When you speak about human rights before the Council of Europe, it's about state responsibility. Now we're speaking about the individual responsibility of those that are participating in the conflict or that have initiated the conflict. So first you can think of deterrence of further crimes, preventing crimes from happening. Punishing is an obvious one. Express social disapproval of a particular form of behavior. Bringing justice to victims. And you have broader purposes such as providing a historical record of what's happening, helping reconciliation, contribute to the maintenance of peace and security. Now, whether we will actually reach any of these purposes in this situation is difficult to say. And I'll try to speak about it in the second round. So which judicial institutions have jurisdiction over the international crimes currently perpetrated in Ukraine or that had been perpetrated since 2013-14? So an obvious one is the International Criminal Court, right? So that was an international court established in 2002 to deal specifically with the individual responsibility for international crimes. Neither Russia nor Ukraine is a party to the ICC, the International Criminal Court. So initially, for a situation to fall within the jurisdiction of the ICC, you need to have at least one of the two states, the territorial or the state of nationality of the perpetrators, to be a party to the Rome Statute. In here, we don't have that. What we have is Ukraine issuing an Article 12.2 of the Rome Statute declaration, saying that it accepts the jurisdiction of the court. So not ratifying, but accepting with regards to specific events. In 2014, it accepted the jurisdiction of the ICC with regards to the Maidan events taking place at the end of 2013, beginning of 2014. And then some years later, it accepted a second time the jurisdiction of the court from the end of the Maidan events, or if you prefer, from the beginning of the Crimea invasion and the conflicts in eastern Ukraine onward. So from 2014 onward. So basically, the ICC has jurisdiction over what's happening in Ukraine since end of 2013. However, the fact of not ratifying the Rome Statute for Ukraine implies that Ukraine cannot submit or request the ICC to immediately intervene. And that was an issue when the prosecutor of the ICC, Prosecutor Khan, was seeing what was happening on the 24th of February onward. it had to ask the permission of the ICC to start an investigation into what was happening. And asking the authorization of the court entails that you cannot send your investigators on the ground, and that you need to wait for the judicial process of submitting your evidences showing that there are substantial ground for the ICC to investigate. And that would have taken months before it takes place. And so we would have had to wait 3-4 months before investigators being sent. Now, what happened 1 week after the Russian act of aggression is that 41 state parties to the ICC, so state parties, those that ratified, referred the situation in Ukraine. 41, all EU member states, Japan has joined, 2 states from South America, Canada, New Zealand, Australia, have all unified and use that power that states party have to refer the situation in Ukraine. What that means is that from the day after, the prosecutor could send its investigators on the ground. And so now we have an ongoing conflict with investigators on the ground. The ICC has jurisdiction over war crimes, crimes against humanity, genocide. It also has jurisdiction over aggression, but for the crime of aggression, the jurisdictional scope basis differs. So for war crimes, crimes against humanity, and genocide, as long as the crime is perpetrated in the territory or by a national of a state that accepts the jurisdiction of the court, it falls within the jurisdiction of the court. For the crime of aggression, you need to have both states that are implied, so the territorial and the state of perpetrator, ratifying the Rome Statute and ratifying the Rome Statute. So for now, we don't have the possibility of the ICC to investigate whether the crime of aggression has happened in Ukraine. You could have a Security Council referral solving this impunity gap. But you know, Russia is part of the Security Council, so it will obviously oppose its veto to this. And so we have the possibility of not having ever the question put before the court, the ICC, whether the crime of aggression was committed in Ukraine. So should we talk about national courts? So we do have national courts that are using the principle of universal jurisdiction to investigate what is happening in Ukraine. Germany has started an investigation on whether international crimes are committed in Ukraine. But German investigation only includes or cover war crimes, crimes against humanity, and genocide. But leave genocide aside in this case, because beside Russia claiming, nobody takes seriously the claim that genocide has happened, or at least we don't have proof that it's about to happen for now. Spain is also investigating. Poland is investigating. Obviously, Ukraine can investigate. The only state between these that I said, which are taking affirmative steps in investigating, the only state which has jurisdiction over aggression in its criminal code and possibly with universal jurisdiction, is Poland. But for Poland to exercise jurisdiction on aggression according to its domestic code, you need to have one of the perpetrator residing in the territory of Poland. So we see here the chances that that happens, prosecution for aggression, are very low. I just want to conclude with one thought on why it's problematic that we don't have high prospects, except if there is a regime change in Russia and that it ratifies the Rome Statute, or I can also speak about other avenues later. But if aggression is not prosecuted. So what is aggression? Nuremberg defined aggression as the supreme offense, the supreme international crimes, as it includes the accumulated level of all the other crimes. So basically you could think that thanks to aggression, war crimes are taking place. Thanks to aggression, crimes against humanity are taking place. Thanks to aggression, it gives sources to genocide. There is also an additional view on that. The act of a state using aggressive force against another, committing the crime of aggression, from that moment in law, it brings into play international humanitarian law. So for international humanitarian law, so the law of war crimes, you need to have a conflict. And once IHL, international humanitarian law, applies, then there are certain conduct that in terms of peace would have never been allowed. So you can have civilians dying out of collateral damages because the building beside was a military target. And this would be lawful if it's not clearly excessive to the military advantage. Now it's aggression that allows this. It's the act of aggression that permits this regime play to come into force. And that's why you need actually to think about the culpability of someone who triggers IHL. That's one of the value of talking about aggression. The responsibility for all that became legal afterwards. Thank you, Başak.
Thank you very much, Skander. So I'm just going to look to all my panelists if there's anything that they would like to add or comment to others, or I'm also very happy to take questions or comments from the floor. Please go ahead, Yulia.
I wanted to make two broad points. First, about the International Court of Justice and generally international courts. I think, again, my first intervention might sound like a very pessimistic view on international law and the international courts, but I think it just an attempt to make people and decision makers to think about what they can do to change the situation. Because again, even small issues that I touched upon, for example, letting a party not appear in proceedings, that's a procedural issue, but it has been going on for years, and not only with regard to Russia. The question is, should international courts deal with it in any way, or should they just allow states to behave themselves however they want? So I think, again, the situation in Ukraine now, it raises a lot of questions and highlights a lot of gaps in the international legal system. And I think, and that's the point I wanted to highlight, that now it seems that we have a lot of political will, and there is a momentum that international lawyers can use to change and to improve international legal system. The second point, I wanted to go back to what Cathryn touched upon on refugees from Ukraine and seekers of protection from Ukraine. Also, just to highlight the specific demographics of Ukrainian refugees. So these are mostly women and children. There's an increasing number of unaccompanied children and elderly men. Ukrainian men are not allowed most Ukrainian men are not allowed to leave the territory of Ukraine. So again, because of these demographics and because such a significant number is staying in Poland, and although Cathryn already mentioned that they are allowed to move on, but I think a lot of Ukrainian refugees are hoping that the war will be over soon. So they're staying on in Poland with the hope that they can return. So again, there is a huge strain already on Poland and its resources. And there are particular rights that are relevant to this demographics of refugees, like right to education, right to healthcare, and family reunification that should be provided for, and they will require a lot of resources. So I think it's also important to highlight that some of the countries will need additional support from international community. Thank you.
Thank you very much, Yulia. So I have a couple of questions in the chat, but I wanted to come to you, Tomer. You had a question. But you need a mic. You need a mic.
Yeah, so this has been very, very interesting and illuminating. And this is sort of, it's not in my mandate on the panel, but I've just been thinking, you know, the ICJ application is very unusual. It does lots of acrobatics for reasons of jurisdiction. Okay, the closest I can think of is something in the WTO. We have a case about continued sanctions. You know, I'm not in violation. Why are you taking measures against me? The ICC, of course, has to go through so many hoops before anything happens. So I was just wondering if, an advisory opinions of the ICJ have been no less effective in the formulation of international law, certainly in the area of, they're non-binding, at least formally, but with respect to aggression and so many other areas, then perhaps an application for an advisory opinion by the General Assembly, and we know what the majority has been with respect to condemnation. Is that something that has been considered, or should it be considered?
Thank you, Tomer. Judge Jutevska, would you like to come on that question? I see that you're on screen. And of course, the General Assembly resolution does recognize the action as an act of aggression with the 144, I think, votes in that regard. Would you like to come on this question of an ICJ advisory opinion, Ghana?
No, actually, this is not my cup of tea. The only thing I wanted to add at this moment, exactly, I agree very much that there is a momentum for international law, as the world was never as united as it is united today. 144 states voting in the General Assembly in UN, this is really something. And yes, we should invoke as many legal avenues as possible. ICJ, European Court of Human Rights, International Criminal Court already addressed. You know that there is now a call to create special tribunal to bridge the gap for crime of aggression, so to address precisely crime of aggression against Ukraine. Another legal, well, not legal, maybe quasi-legal avenue just launched. You know that 44 states invoked the, 45, sorry, states invoked the OSCE Moscow mechanism, human dimension mechanism, which means they would create an expert mission to address concerns regarding humanitarian and human rights impacts of the people on the people of Ukraine caused by Russians' invasion. So again, it will be panel of experts gathering all possible evidence. And when all this mechanism taken together will be pursued and will reach some sustainable result, I really believe it's a very important moment for international law, and we all will somehow participate, and let's hope that this time we will create something that would prevent that so awful atrocities as today from happening again. Maybe it's naive, but we should do our best. Thank you.
Thank you, Ghana. Maybe there's a question that you may be able to respond to. So I'm piling up a few online questions, but I'll group them, and this might be relevant maybe for you as well. So there's a question about Ukrainian civilians that are evacuated to Russia and by Russia. So there's a question about, whether these, whether these are individuals that are evacuated willingly, or have they been forcefully moved from Ukraine to the Russian Federation? If there's anyone to comment on that, and if they were coerced to leave Ukraine to Russia, so against their will, what will be their sort of legal situation? And then there's a question about the status of people in the occupied regions, which is a separate type of a question. But I just wanted to ask if anybody wanted to comment on it. But I'll look at you first, Ghana, if you had any comments, or if there were any applications before the European Court of Human Rights in relation to this coerced evacuation to Russia from Ukraine.
For the time being, we don't have any. I mean, you say any evacuation is a forced evacuation. People are not leaving their homes of goodwill. Of course, they are forced to to live because of the military aggression. Now, in the regions which are closer to which borders the Russian Federation or occupied territories of Donetsk and Lugansk, we see a lot of people going there because there the corridors are open. So people are going there, again, not out of their goodwill, but they are obliged to go, otherwise they would be killed in Mariupol or cities like that. So how we will, and what will be their fate afterwards? That's a very serious question, and we all are very concerned how these people will be used and what in principle might happen to them, especially if they demonstrate their pro-Ukrainian attitude. It's really a very, very serious issue, but it's too early to say anything about that.
Cathryn, did you have any comments on this one?
Yeah, I think it's important just to understand the human rights framework here too, where collective expulsion is a human rights violation and under certain circumstances may also be an international crime. And the question of how then one assesses whether an act is forced deportation or expulsion or evacuation really depends on the background circumstances and a very granular understanding of what happened. Because as was just stated, if people are fleeing or they're being evacuated, of course, they don't have a normal range of options to assess the consent to leaving that place. But I think this is where that line between evacuation with assistance and actually forcing people out of a territory in a way that would amount to a collective expulsion, I think there is a clear discernible line, but it's very difficult to draw on the facts sometimes. But given what we know about the background circumstances in these occupied territories and the likely human rights, the possibility of serious human rights violations being perpetrated against them in Russia, I think that means that whole scenario looks quite questionable. So I think but an awareness of that line, I think, is quite important, and that I really think that's also why this question of humanitarian corridors isn't a panacea. It's a label for a set of practices, and talking about regular ceasefires where people would have a range of options about how and when to flee. Is something that experts on conflict and on humanitarian affairs would favor often much more so than over just very narrowly defined humanitarian corridors which direct people towards certain territories. And so I think actually there's a much more granular discussion to be had, and experts like the ICRC need to be involved in the whole humanitarian system about regular ceasefires and protection of civilians in general in positions of conflict. But I think partly because we're only 19 days in, and also because there's such a lot of commentary, slogans like humanitarian corridors get invoked a lot, whereas actually you should be really thinking about a whole system to protect civilian life in conflict, which probably includes much more regular ceasefires and also monitoring and trust building. Because at the moment there isn't enough trust for civilians to be able to trust that even if a humanitarian corridor is open up, that it's going to be safe, because there's already been documented bad practices where people have been trying to flee, where they understood that there would be a ceasefire and they have found themselves under fire.
I'm just looking at Yulia. Would you like to comment on this particular point?
Also, just some of the things that were reported in both Ukrainian and Russian news in terms of evacuation of particularly people from occupied Donetsk and Lugansk regions. It was reported that 2 weeks before the war started, women and children and elderly were evacuated from these regions. It is hard for me to say whether they were willing or not, but from the interviews and reports that I've seen, people are just very tired of the war, and especially in those regions. They've been living in the armed conflict since 2014. So I think, again, and I think Ghana and Cathryn both highlighted this point, that it's not about the options, but it's more about the safety. They were offered this opportunity to be relocated to Russia and they went there. I'm not sure they had the any choice or even any opinion in terms of how do they relate to Ukraine and Russia. I think most people, at least in those regions, it seems, are just very tired of the war and wanted to be in safety.
Thank you. I have a cluster of questions, and I think I may be able to take one more if anyone in the audience here would like to ask. But I have a bunch of international criminal law and responsibility questions, Skander. Perhaps you can answer them briefly. So one range of questions people asked is about the use of universal jurisdiction in Germany, in Spain, and elsewhere. That whether this could be a political pressure tool. Whether this is something that should be pursued even more, for example, that the universal jurisdiction should be used for international crimes. And a second question has to do with, how could we prosecute the crime of aggression or the individual criminal responsibility for aggression if this crime is not something that Russia has accepted. So wouldn't it undermine the principle of legality if an individual was convicted of the crime of aggression? And I think there's a linked question about this, and someone's wondering, are there any possibilities of the head of state or others directing or leading this operation to be prosecuted?
Thank you very much. So I see three questions. The first one on universal jurisdiction, and let's speak about universal jurisdiction for war crimes and crimes against humanity in this case. Universal jurisdiction for the crime of aggression is a contested concept. Between 20 and 40 states have legislation on universal jurisdiction for the crime of aggression, but most observers, commentators are raising doubts about whether this is actually in conformity with international law. But so I'm going to stick for now on crimes against humanity and war crimes. And I do think these are important tools in addition to the prosecutions before international criminal courts for indeed putting pressure. And let's be clear. Universal jurisdiction cases that happen at the domestic level will never be against the head of state or what we call the troika, the Minister of Foreign Affairs or the head of government, even the Minister of Defense. There are doubts about whether this would be illegal or legal because of the immunity that they may enjoy under international law. But having prosecutions at the domestic level against people less high in ranks does put pressure on the individuals. They cannot travel anymore to the state where they're looked for. And if you involve Spain, Greece, Italy in these prosecutions, then this means a lot of Cyprus, a lot of summers that go away, right? The beach is not accessible anymore. And that has a price. I mean, that plays a certain effect on the moral of the people that are fighting, on their family, and it curbs your freedom of movement. And also it passes the message to soldiers that receive orders, or that they may also be sought for if you go even for the generals. So I think it's important that states pay the duty, because at the ICC you will have a handful number of cases. The ICC cannot go after everyone. So I think states have to intervene when they receive people as refugees. They can take testimonies and so on, gather evidences. Now, the second question about the legality of the crime of aggression, if an instance is established to prosecute it at the ICC or before, I think we know what the definition of the crime of aggression is. It's not very far from the one that is contained within the Rome Statute. There are some debates about whether or not it reflects customary international law. These debates can take place. I think they have to go before a court, and a court will check whether or not the definition within the Rome Statute reflects customary international law. And it only needs to be applied to the individual it's not the question of launching a prosecution on aggression after it happened or exercising jurisdiction over aggression after the act of aggression took place. This is not the issue. The issue is applying the correct definition that applied at the time on 24 February 2022, or take 2014 for the aggression that took place in Crimea. So I don't see a real issue there. It just needs to be assessed what's the definition, and then you apply it to the individual. And then the third one is a big question, whether immunities for aggression, they obviously apply. There are doubts whether even functional immunity can be said to be inapplicable for the crime of aggression. The International Law Commission did not list aggression as part of the crimes for which functional immunity does not apply. Germany, I think, opposed quite clearly to the non-inclusion of aggression within the crimes for which immunity, functional immunity does not apply. And functional immunity is the immunity of all state officials, not only head of state, Minister of Foreign Affairs, and head of government. Now, for these three, heads of state, Minister of Foreign Affairs, and head of government, the idea is that the idea that is proposed at the very least by the International Criminal Court is that these immunities do not apply before international criminal courts and tribunals. So ICC is a clear case, but other courts that would have the status of being international, immunities would not apply before them. Now, there is a debate about what are the specific characteristics that need to exist for these courts, whether a court established by 2 or 3 states would qualify as international, and therefore it can prosecute any head of state before it. There is a debate there. My view is that the General Assembly, as used, is Uniting for Peace resolution powers, and I think that if the GA either can refer a case to the ICJ, I think it's something to be taken into account. It could also endorse an ad hoc tribunal. So we have a project now submitted by Gordon Brown, former Prime Minister of the UK, is to establish a special tribunal for the crime of aggression against Ukraine. And I think one important element for this special tribunal, if it was to be established, so without the Security Council and established by states, I think it would need an endorsement from the UN General Assembly. And I believe that this would show that this tribunal is endorsed by the international community and that it represents, it has sufficient legitimacy to exercise jurisdiction over the crime of aggression. And before that tribunal, immunities of head of state and the other of the Troika would not apply, I believe so.
Thank you, Skander. So I think we have come to the end of our tour de force. I think we have covered an incredible ground. I'd like to thank our online experts and speakers, Judge Judivska and Dr. Ioffe, and also here I have my wonderful experts who have contributed. And we have covered a very big range, and I think maybe going back to the beginning, a lot of people are generally very disappointed with international law, because I think, one of the things that we always see is that international law is always violated, and that creates quite a lot of disappointment. But perhaps it's helpful to think that one of the things that international law offers us to be able to talk about how and under what conditions and in what terms international law is violated. So perhaps that's one way of thinking. And of course, in particular, this event makes us think about what then are the responses that individuals like us, academics, students, scholars, those who are actually working in different fields, states, corporations, individuals, I said that right, international organizations. So what do we have to do? So I think this was an excellent panel for us to reflect, not to say, oh, international law is violated, but I think perhaps the correct question is then what, and what needs to happen and who does what. So I really thank everyone for bringing our attention to the second dimension here. And thank you once again for everyone who was online and also on site. Thank you.